look at the regulation currently in place and come up with recommendations. The idea being that we were dealing with the complaints from neighbors about the impacts of marijuana operations, and you are also dealing with complaints from the industry, as we've come to refer to it, about the uncertainty permitting process. The advisory committee met for several months and came up with a recommendation, which they then presented to you. You adopted their recommended code revisions as interim controls and repealed the moratorium. That triggered transmitting the proposed code amendments to the Planning Commission, who actually had begun their work back previous to May, but due to the high water events, their consideration was postponed until June. They conducted a public hearing in June, continuing it to July. In July, they also toured 2 farms to see what a marijuana operation looked like on the ground. At the conclusion of their research and deliberation, they, go ahead and bring up the code section, 178290. Actually, go to the district use chart. They came up with a recommendation. They amended the proposal that came forward out of the interim controls in this manner. Projector's not on.
Sorry, I'm not sorry.
Well, while everything's warming up here, you'll recall that one of the subjects that seemed the most difficult to deal with was impacts to the neighbors, mostly odor. There were other lights, fences, other issues, but odor was the tricky one, if you will. Now, a lot of debate with the advisory group, a lot of debate with the Planning Commission, and debate amongst yourselves for that matter. 2 approaches were considered in the broad strokes. One, distance to ameliorate the impact, and it was the information gleaned from the advisory committee that the distances necessary to have a measurable, or if you will, a perceived impact were pretty vast. So the approach that they opted to take was, rather than to minimize the impacts to any party, the approach was to minimize the number of people impacted. Hence the definitions for high density and the prohibition against citing marijuana operations mostly grow indoor and outdoor in those high density areas. The idea being, well, certainly people close by would still be impacted. If you're true to the requirements of the code, there'd be fewer people. There were some setbacks built in. They weren't anything comparable to the distances that they discussed earlier in their debate, but there were some setbacks that were created from the county roads, from lot lines. They opted to treat fences as structures, which brought into play the lot line setbacks, as opposed to the way we usually administer fencing, which is to put it right on the property line. So your marijuana fences are not treated as structures from the viewpoint of enforcing your lot line setbacks. What they did do, and this was tied to the concern, while the language of the code prevented citing marijuana grow operations within high density, set a buffer around the high planning commission. So the planning commission has amended state 220, your district use chart, to require a conditional use from R1 zone and a conditional use permit in the Met-How review district. R1 zone is your 1 acre zoning, slated obviously for high density district. While a mixed bag, you do have some 20 acre zoning in the Met-How review district for the most part. They thought it was appropriate to select the Met-How review district for a conditional use permit. The idea behind that, of course, a conditional use permit by its nature is a site-specific evaluation. You come out of the chute, if you will, from the viewpoint it's a permitted activity if you can condition the point that the potential impacts are mitigated. So that was the approach in terms of 178220 that the planning commission took, and again, it was just a desire, operation do not site in your high density areas. Go ahead and go to the code section. Now, the definition I'm speaking of, go down to high density. So here's your definition of high density, and they took it from the viewpoint of your basic, if you will, lot size and the level of build out. So your 2-acre subdivisions requires less build out than your 5-acre subdivisions, and then following is the fencing setbacks that they built into the code. Now, if the way this would play is if you were to adopt 17A220 as they've recommended, all applications in the R1 zone would be required to obtain a conditional use permit. You would still apply this standard. So if someone in a high density area, well, they would be able to determine that before they applied for the conditional use permit based upon this definition. Now, the ones on the line, we really haven't any kind of policy direction in terms of whether that would be compatible for CUP or if they could buffer with additional distances or something like that to make it compatible. So go down to the enforcement section. The other change that the Planning Commission offered is this, and actually as the code section was revised, there wasn't an enforcement section. It would fall under the general enforcement provisions of Okanagan County Code 17A, but once again, the discussion of code enforcement entered into the more specific discussion of the regulation for cannabis operations, and the Planning Commission believed that a specific reference to the enforcement section was appropriate. In a nutshell, that is how we got to where we are today. Any questions of staff before you move to public testimony?
Could you move back up to of the high density? On number 8, it says no outdoor cannabis production operation may be cited in high density area, defined as follows: lots created by a subdivision or short plat in which the predominant size is 2 to 5 acres, and having dwelling units built on the following percentages of parcels in the subdivision. So dwelling units have to be built. You have to have dwelling units present to make the high density happen?
Yes, this discussion came from a recognition that there are a number of high density subdivisions that are still in single ownership. None of the no build out. Concern was that that person would not be able to site, even though they arguably control all of the surrounding property. So they came up with a measurement, if you will, that while it may be a high density division of land, if there was no building activity and the marijuana operation sited, then any subsequent residences would know up front that it was there. Or on the other side of the coin, if there's already a level of build out, marijuana operator would know that you already have neighbors there. It's not an appropriate place to site. There was no particular magic in the numbers. It was the results of the discussion that arrived at these figures.
I suppose that was probably discussed quite a bit. Then the operation becomes the predominant use and it rules the subdivision in essence.
That was an element of the discussion. If you have even though you have the lots created, there's nothing there. So in anybody then subsequently buying the lot for development would do so with the knowledge that there's a marijuana operation in the vicinity. One of the pieces of this that is different from not regulatory framework is Previous, there was no effort to bring existing marijuana operations into compliance with the new regulation. In this particular proposal, some of the requirements existing operations would have to come into compliance with after an amortization period. Citing is not one of them. If you're legal pre-existing on your lot, then you don't have to move, at least in accordance with this. You will have to downshade your lights, you'll have to keep your fences up to a particular standard or install them to a particular standard. Those things you still have to comply with, or will have to comply with after a period of time. But the actual legal pre-existing site you would retain in accordance with 178330.
Can you go to the section in this code that shows those requirements that existing users are going to have to meet? I believe it.
Scroll down. Stop. Where am I? There we go. Legal pre-existing. Legally established cannabis operations in existence prior to the adoption of this code are considered legal pre-existing according to 178330, except cannabis operation will be required to comply with 178290 will force your new code section, subsection B, 2A, B, and C, E, F, subsection 6, 7, 10, by January 1, 2021. So we can roll back through all of those so you can see what they are. Go to 040, 1704. So, conditions of approval.
B1 was the first one.
So your fugitive dust, visible emissions, fugitive volatile organic compound emissions, odors, noise, disposal of waste, all those your legal pre-existing will have to come into compliance with.
Where is the visible emissions?
Smoke, those sorts of things. Your odors, now here's another point of discussion with both the advisory group and to appoint the planning commission. The requirement in the WAC on odors essentially ties it back to an industry standard. So long as what you're doing is generally compliant with, if you will, the equivalent of the best available science in the agricultural industry, and this is an agricultural statute, then it's assumed that what you're doing is not unreasonably intrusive to your neighbor. So, there was a little bit of, it's something of a circular discussion. The odor offends the neighbors, but if the odor is only present during that 2-month or so period of time that the plants bud, and there's an unusual practice in place that makes it worse, then you're arguably in compliance with this section of the code. There's no broad, I can't move through this whack a particular standard. So the reliance was not on this to combat the odors. That came up at one point in the advisory group. As long as you couldn't establish you're in violation of the WAC, then you're okay. But the high density prohibition, the setbacks that were put in place were also directed primarily at odor as additional mitigations.
So, right now, if, let's say that production practices could change to allow for multiple crops within a year, then does that become an out of standard practice?
It could be considered as such. The line in there, and it's wavy, is whether they're high widely spread, if that's become an industry standard, or if it's a very isolated circumstance that one is practicing. It's kind of and the reverse would be true as well. If future strains of marijuana plants are created and become commonly used that don't have or have less of that odor, but you have somebody that's hung on to the old way, if you will, and is growing a strain that does generate a lot of odor, okay, is that now still an accepted industry practice? Or have they kind of gone off now into the status of renegade, if you will? So there's, distinction in terms of how effective the application of this particular WAC is going to be. And that's been pretty much acknowledged all the way through the process.
That's the WAC that controls agricultural operations, does it, but it's, the right to farm, ordinance that we have, that exceeds that even. I mean, the right to farm ordinance exceeds that in allowing, more prevalent odors.
Well, the right to farm ordinance, you might recall, was revised and adopted as an amendment to the previous right to farm ordinance after it was struck down in Yakima County. And the language in the right to farm ordinance on the books now is similar in tone to this series of WACs. The right to farm ordinance recognizes that, or rather allows, or protects is a better word, the agricultural operator from nuisance complaints, lawsuits, and that sort of thing. But it still requires that the agricultural operator be in a position to demonstrate that what they're doing is an acceptable practice. So, they're similar in content. This, of course, doesn't protect anybody. Well, no, that's not true. It actually does. This series of WACs, to a point, protect, and it's directed toward providing you're operating within these industrial standards, then you're not in violation. The WAC doesn't go as far as the right to farm to actually create a legal shield between a nuisance complaint, but they speak to the same thing.
Right, that's kind of what I'm getting at, because we dealt with odor here recently, and a recent complaint in an agricultural use, and the odor is pretty bad, I found. Chicken coop.
Stout stuff. But if in its application, it's a good example, by definition, it's odorous. But if it's applied properly and applied in a manner that is consistent with agricultural operations, under this WAC and under the right to farm ordinance in Okanagan County, you'd be protected. Now, and I guess carrying on then with that comparison, the additional restriction on marijuana operations is the prohibition against putting that operation in a high density area. No such prohibition exists for agriculture, so this is a step beyond that, if you will, which is outside of the requirements of the WAC. And it's also, and this was part of the discussion as well, it's a little bit different from your usual approach to zoning. In zoning, ideally you identify zones where they're compatible, they're permitted or conditional, prohibited. This discussion came out of a recognition that for so many years, 40 or so, Okanagan County had essentially one zone outside of the Med-How Review District, and they were all 1 acre lots, or allowable 1 acre lots. They weren't all 1 acre lots, but it did allow that level of density pretty much anywhere. So, changed in 2016, all of those old, scattered, if you will, high-density developments still exist. So rather than try to identify specific areas where marijuana operations would not be compatible, the advisory group, which was embraced by the Planning Commission, went to the definition instead. So while you may be in the iteration of high density, if you adopt the proposal as amended by the planning commission, while you have to get a conditional use permit in the R1 zone, you still have to stay out of the high density areas. Even though it's still a permitted activity in the R5, you still have to stay out of those areas which meet the definition of high density.
So is there any reference to our nuisance code in this?
To what? I'm sorry,
Is
Commissioner?
there any reference in here to Okanagan County's nuisance code?
No. Go to the enforcement section. This citation, 178360, has provisions in it for the declaration of a public nuisance. You have criminal sanctions for violation of the zone code. So this reference takes you 178360, which is where, in the parlance of zoning, where there's the opportunity to go to the court, have something declared a public nuisance for enforcement action, or you take the more traditional approach of trying to cite it in to the prosecutor, to the court, the prosecuting attorney's office.
Okay, because I was reading read the section up there on noise.
Go to noise.
Right there, E. So, compliance with BOCC 9.6 with that, or?
That's your noise ordinance,
Noise
which
ordinance.
prescribes hours in which you have essentially a rebuttable presumption that noise in excess of what would be normal is a violation of your code. Other times of the day, you would have to establish that it's an unusual noise for what you're doing. And there's actually some examples of that, amplified human voices and that sort of thing. The others are, the WAC citations are actually in the WAC enforced by the Department of Ecology, and that's essentially a chart that shows what is a permissible noise level at the property line of different types of property. Your noise level that's acceptable in an industrial zone is different than your noise level that would be acceptable in a residential zone, that sort of thing. So while these are often referred to as nuisance sections, the nuisance section that's cited in the enforcement section of this is your nuisance declaration in your zone code. Other questions, Commissioners?
Very well. We'll wait for the clerk to return. Yes, we got that. See if anybody signed that. Okay. So we have 2 yeses and 2 nos. Is there anybody else that came in that would wish to sign up to testify in the public comment? Okay. So as soon as the clerk returns, we'll start the public comment. that wish to testify are Jerome Feel, is that correct? You'll be first? And then BOCC, Friedman? Okay, you'll be next.
Is it here?
And you'll state your name for the start out, please.
Okay, my name is Jerome Feel, and I live on Benson Creek. And here, again, I was here in June of 2014
Just scoot that mic just a little bit closer to you.
and gave a very lengthy presentation on what was about to take place on Benson Creek. And Commissioner Detro, Campbell, and Commissioner Kennedy and Perry were present. And I've been in this room when it was packed out the door. And I've been at the Ag Center at numerous public comment periods and planning committee meetings. And I can assure you that if left to their own devices, the people on Benson Creek have not done one thing to make living on Benson Creek, that grow complex, any more palatable to the neighborhood since the day I started sitting here. It has not changed, and if anything, it's probably gotten worse, because a continuous revolving door of people coming in and out of that place, and I don't check it all the time, but if you go on the Liquor Control Board under the Cannabis requested reports, you can see who's assigned to that complex or that site, and it changes quite regularly. We have 4 producers, and now we have 7 processors, all under that one location. And it changes. We see faces come and go, and it's all leased. The landowner's main objective is to carpet that property from border to border with as many tenants as humanly possible. And our new neighbors basically depend upon who answered a Craigslist ad in Seattle. I'm pretty convinced of it because I've seen it. You can go on the farm and garden Craigslist ads in Seattle, and they are advertising Okanagan County properties for sale very, very regularly. So I don't know if the county knows what the commercial corporation basically, and it seems to be being protected under the guise of agricultural and farming, but a white truck shows up, it unloads a bunch of pots, these guys water that plant, and then they process it. So I don't see how that's farming. And as far as the topic that was brought up about having multiple grows and multiple blooms, they don't have to grow their own plants. They can bring in brand new mature plants off that truck in June or May or whenever. So it's not like it's a normal agricultural growth cycle where you plant a seed, you nurture it, you fertilize it, you water it, and in the fall, you've got a crop. Those crops get imported via those trucks on a regular basis. So there is no normal agricultural growth cycle. They can show up as soon as the snow's gone and start having 6-foot mature plants if they want to. So it just doesn't seem like the county really has a good handle or has identified this particular circumstance. If it was an individual sole proprietor farmer who had a grow operation off the road and they tended and cared and looked after their, neighbors as we do amongst each other, probably wouldn't have a gripe about it. I really don't care about, it's just like alcohol to me. As long as you don't bring it to work, as long as you don't give it to your kids, and as long as you don't drive and hurt somebody, I don't care. But what's on Benson Creek is not a farm. So it just seems that with the turnover and the extent that there's these new occupants or tenants coming in, that there's no end to it, there's no restriction. What's the number that's too many? Is it 10? Is it 20? I guess I need to know, so when it's time to move, I have a number. You know, what's gonna be too much that the people around that place can't stand it anymore? Because it's there now, I'll tell you that much. People don't walk the road, they don't bike. Grandparents used to push their grandkids in strollers up and down Benson Creek, take their dogs for walks, but not anymore. I can't tell you how many times I've swerved because there's no center line on Benson Creek, and apparently some people can't comprehend a left and a right side of the road, and they drive down the middle, and maybe it's the hoodies that they can't see that well, but I've been on my motorcycle and I've been in the car, and people don't feel safe to walk or bike or enjoy their own neighborhoods anymore. So I guess, you know, and the other thing is, it's being taxed as normal property, as far as I can tell. DOR 86 marijuana grow code dictates as far as look at it, but I have less property, I have a smaller house, and I have a garden, and I pay more property tax than that complex up the road. And I don't understand that, because they've got income, they've got lease improvements, they've got service improvements, there's value that that business provides that ought to generate some asset to the property valuation other than just dirt and wood fences, because it doesn't seem like it's being looked at for what it is. And I understand, not every marijuana grow in the county is like that. There are some people who address it as though it's a farm, but this is not that. The owner of that land is never there. All he is pursuing leasing as many different types of services, whether it's grow or processing. He's just trying to fill that place up, and he's doing it, and it's getting worse. And I don't know what the number is that says it's too much. And I don't think the county tracks that. Do you think you've got permits and business licenses for everybody that's been in and out of there in the last 5 years, Perry?
This is a public hearing, this is.
I know,
your
but I'm just
chance.
saying.
It's not Q&A.
I'm just saying,
Because
that's,
if we engage in question and answer, you know, it'll go on for an
okay,
unlimited amount of time.
I
so,
apologize.
No,
And I guess the other thing is, I want to use this analogy because we talked about it at the beginning of this meeting. Everybody in this room knows how horrible it's been for the last 3 weeks to have to live in your house with your windows closed, your doors closed, you come in and your clothes stink. It's hot out. Normally we open up our windows in the evening, get some cool air into the house, get some fresh air into the house, and we have that. I sat out on my deck this morning and it was nice and cool. Had a cup of coffee and a bowl of oatmeal. But you know what? If you live around one of those pot farms, you don't get that break. It's 24/7 stench, stink, traffic, every day. So what we've been living through in the last 3 weeks, if you live next to one of those grow complexes, it never ends. It's just there all the time. There's no getting, unless you leave the area or go, you know, time, I guess. But, you know, I want everybody to think about how miserable it's been for the last month, being cooped up, caged in your homes. And if you live next to one of these grow sites, that's what you get every day. And we were there first. It's not like we all moved in and everybody's got an axe to grind because the chicken coop down the road stinks. We were all there. Life was great. And then this showed up, and there doesn't seem to be anybody willing to look at it for what it is and make a, you know, make a judgment call and try to curtail it, stop it, put some sort of rules or regulations in that are gonna, you know, bring back quality of life to the Okanagan County taxpayers that were there before these people from Seattle showed up. And that's all they are. None of them live here. None of them. And I'm pretty sure that, like I say, the turnover we see is basically just a revolving door of trying to get some and stock up that property as full as possible so that the landowner can get money. I don't see any difference in that as if I put an apartment building on my property. It wouldn't do any more, you know, intrusion, any more noise, any more light, any more traffic. If I put an apartment building on my property on Benson Creek, I don't think I could change one bit what's already been done with that grow complex as far as its nuisance, smell, traffic, noise, light, you name it. The utilities, infrastructure, all of that has basically accommodated this at the expense of the people who have lived there for a very long time. So I just wonder, where does it stop? Where's the number that somebody finally says, well, we got a problem? Because I think that was a while ago. It's passed. So
Thank you.
I appreciate it.
Ms. Friedman?
Hi, so I'm Batya Friedman, and I'm also from Twisp, and I'm also from Benson Creek. And I'm also starting to feel like a regular here in this room. This is my third time coming to a meeting. I came to both of the planning commissioner meetings. I wrote a very detailed email when the first set of regulations came out. I was able to go visit the 2 marijuana grows with the planning commissioners about a month ago. And as my neighbor, I'm here because I think there's a real mismatch between the regulations as written and what it means to live near at least some of these kinds of pot farms. But I also want to say, for me, going to visit the 2 marijuana farms a month ago, there were 2 things that I learned there that real kind of game changer in how I was thinking about things. So all along, I too have been thinking about this as, especially odor, which is what so many people talk about and are troubled by, that this is really, well, 6 weeks to 2 months towards the end of the summer. But both of those growers, and they're growers who I think are seen as exemplary growers. They were members of the Cannabis Advisory Committee, and I think they had some very clean facilities and beautiful looking plants. So they're definitely growing in positive ways. But both of them informed us that they had this summer learned how to grow multiple crops, and that they expected to be growing multiple crops. They have different strategies an expert here, but I left with the impression that we would have a peak, which happens at a certain point in the cycle, from June, say, through October. And, you know, that's all of the summer months, then the peak odor is what has really been a huge issue for people. And so I think that these regulations, when they were being discussed, they were, as I was, thinking about things in terms of 6 weeks to 2 months, but not something ongoing. And I really think some hard thinking about that needs to happen. And at least it was my impression at the planning commissioners meeting, so we all went to see these 2 pot farms, came back and there was the meeting, and that implication just wasn't talked about. I mean, I'm not sure people had a chance to really think about it. I had to go away and actually really think about it and realize how much of a game changer it is. One thing, and that thing that just really came home to me is there are, you know, tier 1, tier 2, tier 3 grows. So we'll talk about tier 3 grows, 30,000 square feet. And in my mind, I'm thinking, okay, you have a pot farm, a grow, and there's 30,000 square feet. But that's actually, and again, I think these regulations were written with that kind of idea too, but that's actually not the reality. The reality is somebody has a piece of land, and maybe they can fit 5, 10, 100, 30,000 square foot grows. They just have to license it to different people. So these prevent some kind of mega, you know, maybe not from the individual farmer's point of view, they have their own 30,000 square feet that they're managing, but from an outside perspective, from a perspective of, you know, odor, noise, light, traffic, etc., it could be 100,000 square feet. It could be, you know, 200,000 square feet. I don't think, unless I have missed some clause in the regulations, I don't think that there's anything to check that at all. I've also gone up and looked at the couple of marijuana grows on Wolf Creek that have very good reputations, and I've looked at what those are like too. And I have a similar impression to my neighbor that when it's a local person who's growing and is there and is really vested, it's a really different kind of thing than the other kinds of situations. And I think at one of the meetings, one of the people who was on the Cannabis Advisory Committee who had one of the marijuana farms we visited talked about, you know, having a 20-acre parcel and choosing, or maybe it was someone else, it's a little confusing to me, but a 20-acre parcel, and they put their tier 3 grow right in the middle. And so then there's really a lot of land that's a buffer, and then they planted trees around it and other kinds of things to really protect their neighbors. So maybe you're not going to be able to, you know, make it completely lovely for your neighbors, but there's a lot more that could be done. And my concern is that these regulations, I don't think, go far enough at all. And I'm also, you know, from the Methow, not just Benson Creek aside, I think about the Methow Valley and the health of the Methow, and I know the Methow more than the rest of Okanagan County, so I don't know enough what to think about there. But for the Methow, a lot of the economic well-being of people is tied to tourism. And, you know, tourists go to places that they think are going to be really pleasant to visit. And the stinky stuff of these farms is just not pleasant. And if it's stinky from June through October, and the Methow gets a reputation for that, you know, if you're on vacation, you pick somewhere else. You know, you go to Leavenworth. So what are the risks to, you know, the economic well-being of at least a part of Okanagan County that is tied to tourism? And then I think one of the other planning commissioners, I think it was Dave Schultz, who might have been sitting there, talked a little bit, I hadn't thought about this myself before, but different geographies, that when you have tight valleys, odor sits in the valley, there's nothing to move it, versus if you have big plains. You know, if you have something in a big plain and there's lots of wind blowing it through, then the odor dissipates. So Benson Creek is a tight little valley. You know, the odor probably sits there. I don't know, I don't study this kind of stuff. I think the pot farms we visited, some of them were on, you know, these big flat plains, and you can see the wind going through. And so maybe some geographies are less problematic than others, but I think these things need to be thought about, and they need to be brought into the regulations. You know, and I think hard questions need to be asked and have been asked, but for me, this issue that the intense peak odors can be there for 6 months kind of changes things. And when I go back and I look at the district chart, you know, I do think, well, if we're talking about 6 months of peak odor, some places in Okanagan County where we just shouldn't have open grows. And I didn't have that opinion a month ago until I learned this new information. But it is changing my views, or at least my thinking, and I think it's something that should be thought about and discussed. So I wanted to share this, and then just some very specific things which I have written about in my very first email to the Planning Commission, where I think for open grows, some things are still not adequate. At least on Benson Creek, it's kind of a hybrid situation. So there's the open plants, but there are also greenhouses. The greenhouses are translucent, and during certain parts of the growing, I don't know exactly, the entire greenhouses are lit up, and it lights up my entire hillside. So I wake up at 2 in the morning thinking it's daylight, walk outside and find out, no, it's just that. So this is solvable. It's solvable by just having shades, you know, and some of the places we visited do have shades, you know, but it needs to be required. That if you're going to it's a choice to use those, choose shades, and then, you know, you pull those shades over your greenhouses from, you know, dusk until, you know, dawn. I do think that that needs to be explicit. Well, we've talked about odor, but I do think that I'm not sure what can be done really for the existing grows. So, because I do agree for existing grows, you ask people to move, I don't think, but I'm thinking about how much of a land buffer around, and really what is being proposed right now I think is too minimal. George Zedel, who was also on this Cannabis Advisory Committee, he was suggesting 50 to 750 feet, and I have to admit I don't really understand those buffers in relation to acreage and things like that, but I think the current amount just isn't adequate. And I really think that this issue of scale needs to be addressed, and maybe it's one tier 3 grow, and then it's 5 miles before you have another tier 3 grow, or some distance. There's something in here about 10 miles between a marijuana grow and a hemp grow. So there's already this idea that certain kinds of crops need to be distant from each other. And that distance is, but something that prevents on a single piece of land multiple tier 3 grows just side by side. It's as if, you know, even stop at tier 3, you know, like, do I really care that it's one, you know, if there's 5 of them and it's 150,000 square feet, do I care if it's one person owning it or 5? I think whoever was thinking, well, we stop at 30,000 square feet, I don't know what was in their mind, but potentially they thought that's enough plants in one area, and then we should have a separation. There's nothing in these regulations that limits that in any way. And so I think that's another thing I would just request that the commissioners look at and think about. And then just, I have a couple small things that I would just note. There's something about appeals and violations written in for new grows, but for some reason it doesn't carry over to existing grows, but I can't think of why one wouldn't have also a reference to violations and appeals. So that might just be an oversight, but I would just call that out. So thank you very much.
Thank you. Laura, you're the only one that has not had a chance to respond whether or not you would like to testify.
I will refrain, thank you.
Thank you very much. Okay, so at this time, we'll close public hearing and open it back to staff.
Commissioners, again, for your record, Operation Director of Planning for Okanagan County. There were some questions posed. Is there other information the commissioners provide?
I think a little bit issue of the density of grow, because if there's a limitation to 30,000 square foot grow and there's several of them, how is that addressed in zoning at all?
There's actually a number of things that could restrict the siting of that sort of size of operation. Mostly your permit exempt well provisions under Campbell Glen. Because according to the environmental review documents we prepared, used the Department of Ecology's calculations with regarding how much water a particular canopy will take. So if you're on a permit exempt well, to meet the why don't you go back to the code section? To meet the requirements for legal water supply, you can only put in 40,000 square feet. Now, if you have water right, or if you're in an irrigation district, then it's a different discussion. It depends on how much water your water right would provide or how much water the irrigation district can deliver. So it's not a control completely across the board. One of the discussions was regarding tracking the different licenses, and we do all the ones that we get notice of. And I'm not going to suggest we get notice of all the changes, but the ones that we do get notice of, we track where they're going, and then we examine the site that they're targeting. If the site is legal pre-existing, we restrict them to their existing footprint unless they apply for an expansion. So we do track that to that extent. So this is your section in terms of your legal water supply. Again, if you have water right, if you're in a district, that wouldn't necessarily provide the sorts of restrictions that people are talking about. The permit exempt well would, based on canopy. Now, we haven't tried to enforce that yet. Doing is extrapolating from the paper that the department, to make sure that no one goes over their 5,000 gallon a day limit. One of the, in terms of back to the question of licenses on landowner sites, Okanagan County Code, not to say it can't be changed, but Okanagan County Code has, since I've been here at any rate, and still does, apply the legal pre-existing status to the land, runs with the title. So you have a site that had a legal pre-existing marijuana there, doesn't matter in terms of your code. So those licenses could and have swapped in and out. Some leave, some come, but if you're legal pre-existing, you have to stay within your existing footprint. Now, under the current regimen, you could permit, but you can move licenses in and out of those legal pre-existing sites, or any of the permitted sites for that matter. Go to amortization, please. We've had the discussion before, but since it's introduced again, the legal pre-existing sites, if you are going to bring them under a new regulatory framework, You have to create, and it has to be a conscious decision. You have to deliberate what is a reasonable time period. You create an amortization schedule. In this particular case, because of the nature of the requirements that the planning committee, the advisory group, planning commission, subsequent to that, decided the legal pre-existing site should come into compliance with your fencing, your lights, that sort of thing. They believe January 1, 2021 was a reasonable period of time to require one to do that. If you reach back to the legal pre-existing sites in terms of their location, and you can do that, there's case law that supports moving non-conforming activities out of a particular zoning district. There's no magic number that I can give you in terms of what is reasonable. The bulk of my experience with phasing out those sorts of things has been in a previous life with sign ordinances. When someone, a city, in this particular case, adopts a new and much more restrictive standard for advertising signs in a particular zoning district, the amortization periods generally were from 5 to 10 years. After that period of time, and then what you're doing is arriving at a period of time that you believe and can defend that the person on the legal, and actually we call it legal pre-existing, the usual parlance of zoning is legal non-conforming. So someone on a legal non-conforming lot or a legal non-conforming activity on a lot, you have to determine what is a reasonable period of time that they have realized a return on their investment. And at that point then, with clear conscience, if you will, you can require them to find a site that is conforming to your local code. That has come up many times. At this point, this has been the proposal in terms of reaching back into the legal pre-existing sites.
Has there ever been any case law or precedent set on not tying the legal pre-existing to the land use? Rather, a licensed activity is licensed until the licensee decides to no longer be there, and then it's no longer permitted.
I can't speak to whether there's case law on that point relevant to marijuana. I know that I've encountered tie it not only to an abandonment, your code does that. If legal pre-existing activity existed on a lot, but you abandon it, I believe it's a period of 3 years, then you lose that legal pre-existing status. Now, some codes tie it to ownership as well, so it's not transferable. In your code, it's assignable, transferable. So if I have a site on which is a gas station that is now legal non-conforming, and I don't abandon it and I sell it to someone else, they can step in and continue to operate that gas station as a legal non-conforming use. Some codes don't allow that. If you sell your land, then you lose that, or you don't lose it, the new owner doesn't gain that legal pre-existing
So
or
the
legal
value of
non-conforming
the
status.
business you established in that location, you lose that value.
Exactly.
That's
Exactly.
what you're trying to protect.
Now whether or not, I'm not aware of any codes, I haven't looked for it either, I'm not aware of any codes that have gone yet, the next step, if you will, that if a landowner is not the operator of that business. So you have the case in Benson Creek where the landowner, and we have actually several throughout the county, where the landowner doesn't hold a marijuana license, isn't involved in the marijuana activity, simply leased to license holders. I don't have any information for the commissioners in terms of what we could do in terms of an amortization schedule that says, or an amendment actually is what it would be, to 178330 that says that only those license holders can exist on that legal pre-existing site. I can't respond to that.
I'm less inclined to deal with it in that way, and because the lease itself is a business too, and so, I mean, if I establish a business, just to be clear, are located there zoning, and we have some issues with our zoning, especially since our zoning's a mixed-use zoning. It isn't really strictly residential. And so we have, we're wrought with conflict from now until forever, until it's from one use to another, because that's what's kind of going on. And that's why I have a concern about the residential neighborhoods are established, I mean, through a process, and they're intended for residential. I mean, many of them are. And the ones that I've seen that have problems, I don't know that this zoning proposal addresses those. So, you know, the one that's clear in my mind is one where it's got houses built, and whether they're built yet or not, I mean, you might have one or two. I see there's a percentage that established that the use, the predominant use, but then an operation that clearly affects a residential neighborhood is allowed to establish and control. That's I think a problem with the zoning in general. So we're trying to fix stuff in our zoning code because we allow these mixed uses anyway. Agriculture is very much the same way. I mean, you know, it's if there's a residential neighborhood, and lots of them get converted the other way. We're having residential neighborhoods converted from agricultural to residential uses. And I've been familiar with quite a few of them where there's orchards that are established, and then the residential begins to come in and take. And in fact, the agricultural use gets criticized. We have a little more protection for them, but there's a conflict. I mean, when you're spraying orchards with orchard spray in a residential neighborhood, there's going to be a conflict. Eventually, it's going to happen. And so, our actual zoning is what really these problems that we're trying to address in a different way. And it's hard to do it. It is. I'm concerned about, again, having these operations that you can't predict. You can't predict what they're going to look like over time. I mean, there's responsible folks in every business or use, but we can't predict that. So the best we can do is really be restrictive on what can happen in a residential area, and they're not strictly zoned residential. It's a mixed use. It's mixed use. It's agriculture and residential. Our rural neighborhoods are. And I don't know, it's not going to be a perfect world the way we address it. So what they came up with, and I see that there's a real effort, but we still have the issue of course, lighting, and I think that's fixable, and it hasn't been addressed in this particular proposal. And maybe we go forward with what we have, and just talking to the board, I mean, maybe we go forward with what we have and continue to address the issues. Because this is at least an advancement. It's not certainly perfect in any way. I'm concerned about the uses that will get established in residential neighborhoods primarily.
I mean, just go back through, and how the commissioners wish to proceed, obviously, is up to you. They were sensitive, the advisory committee and the planning commission were sensitive to your signage being obtrusive, to the lighting. I mean, obviously, the key operative phrase is shielded properties and downcast, so that gives some for those. And then, as one of your public presenters pointed out, some of the marijuana farms, while they have indoor operation with lights, and the tents essentially, but the light can't escape because of the nature of the material used, as opposed to those which use VisQueen, as I used to call it. They may be down shielded for all I know, but we have a tremendous glow, so they're not shielded from neighboring properties. They would be out of compliance with this new code, but they would not have to come into compliance until 2021.
I would argue that the argument is going to be Well, my lights are indoor though. They're inside a shelter. And they are, you know, so we're, because that statement right there says all outdoor lighting. So if you can define, if we define outdoor as being outside of a permanent structure, and even then, a permanent structure might be glass. You're still gonna get that issue.
Okay, fair enough, the intent was to shield neighboring properties from light, so, however, you know, that's been the intent all along, so certainly stronger language here is completely consistent with any discussion that I've been a part of at any rate, so. And I realize you've talked process before, but just for the reminder, commissioners do have the option of amending this proposal. There's a line, it's not bright, I can't draw it for you, and it's essentially your judgment. An amendment of that nature, just as an example, to expand the language to be consistent with the intent of your lighting and your shielding is perfectly consistent with what the planning commission has sent to you. If you make enough changes that are sweeping enough, then one of the questions I will pose to you is whether you want to remand it back to the planning commission for an additional round of public review.
You know, there's the option to take the issues that we don't see adequately addressed and remand it for their consideration. Thinking on that is that it gives the planning commission and the committee, for that matter, an opportunity to address what we don't think has been addressed.
I've certainly remanded the advisory committee. I
Yeah.
didn't mention that, but that's certainly an option as well.
I mean, because there's really valid issues that are brought up, and, you know, as much as we'd like to get things done, there are things that I just think that need paid attention to. Especially when we have to deal with the fact that we have this mixed zoning, and so we have to deal with it in a different way, and there's an attempt to do that with the definition of what's high density and those kind of things, but that also takes the intent of a business. I mean, I have to say that people that subdivide property and go to sell the properties is a business in itself. And they make an investment, and then that investment may be stymied by the fact that there's a use out there that's allowed in the subdivision that affects the viability of the subdivision in itself. So I might have this dream of, number one, making a subdivision that's a nice, and then I might, as a purchaser, buy into that, and I don't have the predictability of the zoning. That's of issue with me, is that there's not predictability of what's going to be next door to me. And when you have a zoning code that says this is this district and this is this kind of a district, and you have a mixed use in it, you're at risk. You're honestly at risk. So those items that have been brought up today are just those kind of issues. Predictability is lacking seriously, and predictability in the lighting thing, I think we should do a better job with lighting. I've been seeing lighting show up in these same districts, because they're mixed-use districts, that's just blaring lights. And they're not marijuana grows, they're something else. There's somebody that comes in and feels that they need an extra amount of security, so they put these lights and they flood the whole country. That's not what we're looking at today, marijuana, but it's an issue. So being able to light your building and cast off this incredible light source, I think we should address it. And not just under security lighting and outdoor lighting.
I don't have any more questions for staff.
You do have?
I don't.
Oh, okay.
It-
Well, we have to remind ourselves too that, you know, I think we've all agreed all along that this is gonna be a work in progress, and we're gonna have to continue to review it because all kinds of problems come up that are unforeseen, and I'm gonna refer to the good operators versus the bad operators. You got some good operators that really make a real endeavor to assimilate into the neighborhoods. And then you have other operators that could care less, so they're gonna push the parameters of every single one of these situations that we come up against, and there are lots of them as today. And, one thing I just wanna remind everybody of is that although we refer to them as marijuana farms, they are not a farm because they're not recognized. And the industry has pushed that issue and pushed that issue. They would love to be recognized as ag because then it opens up a whole new can of worms for everything else in ag. And that goes right back to the referendum when it was passed. Refers to it as a controlled substance in the initiative, and that's the reason that it's not classified ag, and it will never be, and I hope it never is, because it will cause us a lot more problems. We were referred to the tax structure today. Believe me, I wish that there were ways that when you get into a tiered, the assessor has no way, because he is concerned with the ground, the property, and the park. So those, if there were ways to put more taxes on, and I've referred to this too, that, and you all know, that there was a bill dropped last year, whereby the state, with the money that they're collecting, could give $1 million back to each county that would go for criminal justice. That would be a huge thing for our counties, and I hope they do that again. Chris, we could move forward, or we can remand certain portions back, but I don't think we have to remand all of that. We could remand it back to the planning commission and so the advisory committee, which you guys prefer. You want it to go to both? You want it to go to one?
Do you wanna close, just point of order, do you wanna close it to staff and then open it up to the board, or do we still?
Well, you're already in board discussion, staff is just an extension of the board. You've closed the public testimony portion of the hearing. And if I might, since we're on that subject, should the commissioners choose to remand it, we'll of course take the necessary steps to keep the interim controls in place. It would be useful as with any remand, but certainly in this case, if the commissioners are comfortable doing it, to actually offer some level of instruction in terms of the specific areas you're concerned about, not necessarily the outcome, or obviously you just amend it yourself, but in terms of, you know, the areas that you believe you need to look at more closely, would be useful.
No, I'm ready to say, these are the things that I think.
Okay, that's very well.
Do you, are you
You want to direct staff?
interested in a little bit more discussion, or do you just want to move?
No,
No, no.
a bit more discussion.
Okay.
Yeah.
I didn't realize we were in board discussion, I thought we were closing staff, and that's why I said I didn't have any questions. Lighting, so the lighting here is not adequate for me. Because it says all outdoor lighting. I know that greenhouses are not really prevalent in this county except for in marijuana grows. If you have a residential area where you move out to because you want to get away from the glow of the downtown or the industrial park, and all of a sudden you have these huge clear balloons that are being lit up, it's gonna be, you know, that's right there. I just don't think there's adequate provision for covered lighting within clear or opaque buildings.
So, I'm gonna stop you there just for a second. Chris, do you agree on the lighting?
Yes.
Okay, I also.
There's
So
a part
number
that
one.
I don't agree on, is that, and just part of that, and because we've had agricultural operations that maybe they didn't succeed at the time, but there's others that could come up, they were tomato grows and things like that, that were actually greenhouses in the Mountain Valley. And you know, that's something that we need to address in another way, but,
So timeframes
yeah.
are what I'm looking for. I'm not saying don't, like in the wintertime, obviously, it gets dark at 4 o'clock in the afternoon, 4:30. So I'm not saying that you have to cover them all the time. What I'm saying is, there needs to be a time period in which either it's covered or the lights are
No,
on.
I agree with
And
that.
maybe that's 10 o'clock at night to 5 a.m. or something like, you know, somewhere around there. So I'm not saying for the full time it needs to be shaded, but what I'm saying is there have to be those times where it absolutely does.
So, Director, number one would be lighting that we want to address.
Should,
Number two,
For me, the noise issue, we've cited a whole bunch of whacks in here, but I wanna be certain that, because I looked at some of those whacks, I wanna be certain of what the whack is stating. One of them looks like it's, measuring exhaust decibels of like I assume a generator or motor or something like that at 20 inches. You have, you know, large fans that are gonna be going, you might have the potential generator, so I just wanna make sure that the planning commission reads through those whacks really well and understands where that noise threshold actually is, and that there's as little ambiguity in it as possible.
I think something that takes out helps take out the ambiguity is, if we have zoning that deals with the, or any ordinance with the, sound.
Exactly.
Because if you have an ordinance, it's your ordinance that dictates the sound. If we don't have one, ecology's, program dictates it, and it's not as good.
Right, and we do have a noise ordinance on the books right now. I don't know that ordinance is robust enough to take care of this, so.
And I think it should apply to everything.
okay. So, number two, you have noise?
understood?
For me, talking about the densities, the 30,000 square foot densities, it would be interesting to understand where the thought process was when the licenses were brought up, and understanding if they were gonna be able to put 30,000 foot grows together in a daisy chain.
I don't know about daisy chains, but they did recognize it that you can't tier them. You can't stack them. That's in state regulation. So, to one point that, Jeremy brought up is there something that we need to look at and maybe run by even our civil deputy about what you're talking about, daisy chain, and one comes in right after another, just bang, 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 bang. Seems like, there needs to be some kind of, I don't know, I'm not gonna call it necessarily a restriction, but it needs to be separated somehow, so.
Want to be regular, just a
Yeah,
density,
there you go.
density
Yeah,
regulation,
quantitative.
you know, density
So-
regulation of the tier threes.
So today, those that have, several, suites on them, as they can call them, like cannabis and alcohol, those suites are included in a permit that covers the whole,
Correct.
operation,
Yeah.
correct? So that whole operation is controlled by, its size is controlled by the outer perimeter of the operation, isn't that right?
In terms of our regulatory approach. The legal pre-existing ones were confined to what they established as
Right.
legal pre-existing. Now, part of the challenge there is when the commission adopted the regulation back in 2016, there was no requirement, there was no window, if you will, of opportunity to vest your operation. So those that weren't already vested, when they come to our attention through complaint or whatever, the new license application or something, that would trigger the review if they weren't in a spot where they ought to be, the
Right, so-
review for legal pre-existing.
Yeah, they're
So-
legal pre-existing, but that is also addressed because the amortization sunset date is in there, 2021, correct?
No, but not, keeping in mind, not for location. That's part of your amortization, just got, it could be, but it's not at this point. So the point I make is, there was a period of time where people were operating without going through a formal review in terms of their legal pre-existing status. So I can't say necessarily with certainty in all cases what they were on day one versus what they were when they finally came to our attention and we reviewed them for legal pre-existing status. But once they attain that status, if they are successful, they're locked into that footprint unless they go through whatever permitting regimen is required. So in the case right now, permitted in the interim controls, permitted activity in R1, if they want to expand beyond their legal if they're legal pre-existing, if they want to expand beyond that footprint, they have to apply through the site analysis process for review. If they're in a high-density area, we do not expand their legal pre-existing, or if you will, legal non-conforming status. That would be denied. If they're in a position where they could cite, then we review it against the other requirements and make that decision.
You know, this thing that we have set up where this is allowed to have the suites, I mean, that's not addressed, right?
The one, I'm sorry, Chris?
Well, I'm referring to these, I call them suites because that's what they refer. So, say you have a site that has 10 of those on it, and that was the landowner themselves.
As long as they're within the footprint, then we don't count
Right.
the number of licenses, although we are evolving under the banner of legal water supply. If we establish on a permit exempt well, we'll review for overall canopy size.
Right, yeah, and that works, I just would rather deal with something a little more direct, you know, than the water being the controlling factor, because we see that change often. But the thing at here is that was there discussion amongst the group of actually making the permit apply to only the landowner? In other words, we're actually talking about a landowner that wants to run a business and they apply for a conditional use permit and they're the ones that get that permit, and it's not transferable for its use to anybody else. And I know that has implications in regard to leasing property for use, and I'm thinking commercial areas primarily, but you know, I think if it's possible to have a discussion about, you know, and make it be legal, that the permit actually goes to someone, your conditional use permit goes to someone who's responsible. I know it's on the property, let's say it's the landowner though of that property. So rather than it being these permits through the state that come through in just little pieces, and so we're dealing with, and this is what was brought up, and a concern is the owners of the businesses change regularly within the footprint of a permit. And there's something to that needs some discussion. I don't have the solution to that, but that would concern quite a bit. It's like, well, like using these overnight rentals. Overnight rentals became permitted and are a problem partially because you don't know who your neighbor is from one night to the next. You know, so there's this activity that goes on in your neighborhood that you don't know about, and so giving it a sense of community is a problem when you have a transient population that moves in and out of your neighborhood on a regular basis. And while they're a little bit longer in their time span, that's what's kind of going on here, and I could see that that's a problem. You can't even get in a neighborhood and establish yourself as a good or bad neighbor because, you know, you're in, you're out. And then we have the same problem then when we have the assessor looking at properties, when people aren't paying their personal property tax, who you go into, you know, those kind of things. So that there's a problem in that sort of conditional use permitting where the fees are changing all the time.
So what do we wanna bundle that under? That's
Just,
the same thing.
I think just
we're having.
addressing that in some way or another, if we're remanding it.
Exactly.
Yes,
Yeah.
to have a discussion about that, because I don't know if that occurred, did that issue come up in the conversation?
Well, the size, I mean, the size of the operations has been one of the criticisms, if you will, all along. Now, that's always relative to the size of the operation and where it's at.
Yeah.
We have some fairly big operations we don't hear much about. We have others not as large that we hear about fairly regularly. So the discussion was, how to say it, and you all have essentially talked about the same thing, but the disconnect between your license restrictions, I mean, they're all supposed to be under state licensing, small operations. But the cannabis board either didn't contemplate or chose not to worry about the idea of more than one licensee showing up on the same, whatever, 10 or 20 or 50 acre parcel. Now, in other sections of your code, there are, for instance, lot coverage restrictions. There was some discussion of that, but the numbers, while 30,000 square feet sounds like, when you're talking about Maryland acre of ground, it's a relatively modest of the square footage available. So the percentage of lot coverage kind of was dismissed. 10% lot coverage restriction on 1 acre is still 44,000 feet. So if you have a 20 acre parcel, I mean, yeah, you see where I'm going with that. So the numbers didn't add up in terms of trying to get to the impacts.
Well, but the problem was, from what you just described, is it's economy of scale, right? So, yeah, if you were to say, well, we want a maximum of, let's say, 60% coverage on our lot size, by lot size, okay? So if you're talking about a small lot, yeah, talking about a small,
That would have
percentage of difference.
Right.
If you're talking 100 acres, now you're talking about that you can only use 60 of those acres for coverage, and 40 acres becomes a big chunk.
You're
So-
talking about a numerical.
Just like what they do with parking lots, or I think in industrial zone stuff, you have a roof coverage. I think even on lots around here, you have roof coverage percentages, don't you?
No.
Why
You
is-
have your property line setbacks.
Yeah.
I mean, theoretically, you could build out to within 25 feet. Now, some of the zones have lot coverage restrictions, not.
Yeah, I thought I've seen lot coverage restrictions for, roofs.
Impervious.
That's
surface
from,
Impervious.
that's referred to runoff, where you have to build a
I guess what I'm saying is that model is out there.
catch basin and
Yeah.
those.
Yeah, it's impervious surfaces, and those are limitations typically in cities and towns too.
Yeah.
But I think that, not to lose track of the fact that, okay, marijuana operations impacts are relative to size. I mean, if you had 60,000 square feet of a grow operation outdoors, I would imagine the odor probably would be greater than it was in a 30,000 square foot operation. And then when I mix that with putting that in a residential neighborhood, which is kind of what we got in many places that our zoning is mixed. So, especially if you take geography, include geography, and you got a narrow valley, and then you take those operations, so we begin to see a bunch of differences here, in coverage, and so the size of the operation is really relative to where it is, as far as I can tell. And again, if it were Steinfield pickles, in an industrial area, if you ever been down a pickle factory, they smell pretty bad too. They smell really strong with vinegar. So I can list a whole bunch of uses that smell bad. And if I put them in an area that has mixed zoning and say, this is coastal agricultural, I'm gonna have a smell factor, an odor factor that is gonna affect the neighborhood more than it is in another place. So those kind of zoning issues, and then take the differences, you stack a whole bunch of users or businesses in one place with different characters involved in them,
driving on your road and you got impacts. So I see that it's hard to get down to the fine details here, but there's these several items that we're talking about that even with the lighting, we have to consider, I think, possibly more than just these standards that apply everywhere. And I have a concern about this density thing where we're determining whether it's high-density residential or not, when you're establishing a subdivision that's intended to be residential. And so you're gonna stick in the middle of it. It's not working in a couple of locations I know of very well.
Well, but look at it from on the other end of the spectrum too. You have a road over here that's going out through orchard ground. And somebody says, and somebody's got a 40-acre parcel or 20 acre, let's say, in the middle of all that, and they say, well, I'm taking out all my apple trees and I'm gonna subdivide it into 4 5s. Okay. Well, that's out in the middle of nowhere, but it's a subdivision.
Yep.
So if somebody comes in and goes, well, there's no houses built on it, I wanna put a pot farm right there. That's probably acceptable, being as it's out in the middle of nowhere, but it was zoned at 5-acre parcels. Now, as you get closer to, you know, these places, and that's, I think that's where the percentages kind of came in, was, okay, now if you're driving along and that that 4 parcel subdivision has 1 house on it, nobody can put a pot farm on any of those other 3 lots.
Yeah, so one use is established precludes another. It's an interesting way to zone. If I look, there's an industrial area right there in this map right here. And there's some residential around it, but actually the comprehensive plan designation and such has been for, I don't know, 60 years, industrial. I'm not gonna buy a house there.
But somebody might. because
Well, I
it's
know
cheap.
they might, but they will if it's cheap and they think that they can put up with an industrial area, but lawsuits right
Yep.
there is the result of the same thing. And it's not a, there's a zoning designation there, it's industrial. Next to it is heavy commercial, and it works its way out. If you go in there and do subdivision today, you can't, for a residential subdivision, you can't go in and make a residential subdivision because that's not the uses allowed. So what we have is zoning these uses all in the same area. And we end up with this mixed use that's very difficult then to protect the use that it's established for, which we've got uses rural, and we allow agriculture and we allow residential in those same areas. So we have to do extra work in our conditional use process to protect the uses there.
I know, that's the nature of the beast sometimes, though, in a mostly rural county.
Yeah,
I mean,
yeah.
you know, if we're talking about the urban expansion area of OMAC, okay, that's a little bit different,
City
discussion.
expansion.
It is.
Discussion than it is to go out into the hinterlands and, say, well, we got a subdivision of 6 homes, and that all of a sudden precludes agriculture, and precludes, you know, all these other uses. I mean, it's just,
Within the subdivision itself is what I'm speaking of. So I know that I'm recognizing the challenge. And the challenge then tells us that we got to do extra work in our conditional use process to meet that challenge. I agree with you.
Okay.
But to go in there and say, let's do a 6-lot subdivision, and then, oh, by the way, we can locate a marijuana operation in the middle of that 6-lot subdivision, compromises the subdivision. And so I use, and I'll go to, no, just can't name the places, let's not do that, but I go to a subdivision where I see some pretty darn nice houses in it, it's not built out, and then somebody comes along and takes 5 of the lots in a 20-lot subdivision and establishes a grow operation in the middle of it. First of all, nobody else is gonna buy a lot to build a house on. Second of all, you might drive some out, and so you're compromising the value of the properties adjacent to it. And it's in a subdivision, it's not just in the farmland next to it. That's a whole nother story, but I think that we have to focus on what a residential subdivision is before it's built out or built up to a certain percentage. So that part to me is problematic.
Okay, so we all agree, we're gonna remand this back to both planning commission and the advisory.
Okay, I haven't, I mean, if
Because what
that's-
I'm trying to get to right
I
now
know.
is, because we're gonna be running up against a time barrier pretty quick, is have we identified all of the subjects that we want to have Director Houston remand back?
I got two more.
Okay.
One is the odor duration.
The what, I'm sorry?
The odor duration, okay? I think that as, you know, most people, when we were going through this, assumed that this was a crop that produced an odor for a certain period of time. That's acceptable to a certain level, at a certain level. As that gets extended out, that becomes less and less acceptable. So, whatever, you know, if that becomes a thing where, okay, you can, you know, the odor duration can only last for so many months, so be it, whatever that looks like. One more thing, the last thing is the traffic, so if you're processing marijuana, is there any question about traffic flow for processing? Because if you start increasing a farm in itself, you know, you have people that come and pick, I mean, it's kind of like an orchard, you know, I watch it all the time. You kind of come people to pick, you have a few people that work on a, you know, on a day-to-day basis, you get an influx of people when you have to harvest, stuff like that. But with a processor, you have a lot of people that work processing all the time. Okay, so you have just increased the traffic flow to area just because you now have put in a quote unquote, I don't know, semi-commercial use, whatever you want to call it. And so I'm wondering if traffic flow has been addressed anywhere for processing.
Directed towards directed towards cannabis operations at all?
Well, the farm itself, like I said, is a different story. I'm talking about specifically about processing plants.
Understood. The one conditional use permit to date processed for processing, because of the nature of the beast, they had one delivery truck in the morning, one delivery truck in the evening, and actually that was only twice a week, and they had a 4-person staff.
Okay, so that then becomes a non-existent, you know, doesn't need to be mitigated, but what if they're, you know, I mean, the one down the road for me, I like, I have no issues with, but there are probably every day, there's probably 15 there. I'm not saying that the road can't handle it or anything like that, but I mean, there are these differences in scale. You know, if you're talking about 7 or 8 tier 3s with processors hooked to them that are processing all of that material, then you got a lot of people that are processing. So I'm just, that would be something that I would.
Fair enough. Since you've introduced the subject, one challenge we always face, literally with every conditional use permit or a land division proposal that we process, is when you lay the traffic analysis against the level of service classification of the road, very seldom do we butt up against that. If you lay the increased traffic against the actual traffic currently on the road or the perception of the traffic currently on the road, then you can have a fairly significant distinction / impact. There's nothing in your code that really deals with that. Other than occasionally on conditional use permits where you require some small level of improvement or hours of operation is generally how you deal with it many times. you deal with many things through hours of operation. Just an observation, offer up standards are fairly black and white in terms of ADTs and the level of service classification, hence the improvements that it drives, but it really doesn't talk about, if you will, the level of traffic that is compatible with a residential, low-density residential neighborhood. There just isn't a standard there to lay it against. So then you run against essentially the perception of those there, you know, which is a legitimate observation, but that's hard to quantify.
Right, but then
Just an
that-
observation.
Yeah, but then that also allows us to do, you know, a speed, traffic evaluation. That's all, those are the only things that I'd say.
Okay, so, can you regurgitate that for us, what you have?
I can. The commissioners, or at least at this point, seem inclined to remand it to the planning commission. The question of the advisory group is still in. The issues, the particular lighting, language dealing with the containment would be the phrase of lighting on the property during times when it would be an impact. Noise regulation, it was less clear to me the types of noise, so I'm just gonna ban it all together under noise from the operation, looking at not only level, but the time that noise may be generated and what time it might be less or more, however you wanna say it, compatible. Density, I'm a little, I mean, I understand what the issue is, to your observation, Commissioner. The bigger the farm, the more it smells bad. The more traffic, the more lights, the more everything likely that you have. You're looking for a way to deal with that.
Remember that these farms are a maximum in size of 30,000, I mean, each farm,
Each license,
each license, so how many licenses can one person own?
no rate, well, each person, to my knowledge, can have. However, so,
I
upon other license holders.
Yeah, see, that's what they're doing, they're
I know.
branching off and doing
Hey, you got 10 people.
10
who go-
LLCs and
10
Our,
people who go
our
to-
permit should be relative to what we want and not what they permit, right? I mean,
yeah, I agree.
so,
Yeah.
Maybe we need to
Exactly.
address that.
So what I'm hearing, like I say, I'm still looking for the way to do it. What I'm hearing though is something essentially restricting the size of the operation.
Well, and
Defining
What I would
operation.
like-
Also including the daisy chaining effect.
Well, no,
That's what it's
understood,
like.
but let me go ahead and front load the discussion, 'cause we have to deal with it sooner or later. If we say each landowner can only have 2 Tier 3 licenses, you're restricted to 60,000 square feet. That means the landowner with the 5-acre parcel could still squeeze that on, the landowner with a 100-acre parcel couldn't get any more on. Now, that will come up in
And
your
that's
discussion.
where I was going
so.
to the percentage of coverage.
Fair enough, and that would certainly be another approach, if we can arrive at something, I mean, if the commissioners consider an issue, if you want something to kind of equal protection, shall we call it, the guy with the 1,000-acre parcel has the same opportunity in terms of magnitude of scale as the person with the 5-acre parcel, and that might speak to percentages as opposed to an actual number, freezing a lot. That's what I hear the commissioners.
so if you, for me, predominant, and that's location, location, location. So I tried to address it through the fact that we have zoning that doesn't, it doesn't call out this is an industrial use or a heavy commercial use. We don't have zoning like that. So we have industrial, commercial uses in residential areas that are competing with residential uses. So the mantra for business in general is location, 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 and I think the mantra for zoning should be location, location, location. So however we achieve that is.
Since we're on that subject, your zone code actually has a fairly robust suite, to use that as a phrase, of different zoning. But by one example, I think the light industrial zone, there's 17 acres
Right.
throughout the entire
The
county.
county, yeah.
You know, the rest is R1, R5, 20. and look at the difference between R1, R5, and R20, and the district use chart is primarily lot size. So something, I realize that's a huge, much bigger discussion, but for the sake of the observation, there's some work that could be done there too.
I mean, let's just pretend for a second that pot didn't smell. How many people would be upset with it?
Well, salvage yards don't smell, and I get a lot of calls on salvage.
Yeah, okay, true. Pot doesn't look like a salvage yard either. I guess what
Put
I'm
up a
saying
tall
is,
fence, you can't see the salvage
you look
yard
at,
either.
you look at the Barnhole Loop down here, and then if you were to go down valley a little bit into like whatever that is, you know, or even south on the lot, and you were to put in 100-acre pot farm, and the wind is blowing just right. Those
It's like a
people-
landfill. It's conditional use permit, by the way.
I only know of one landfill in the county right now.
Right, but
So.
Barnhart Loop exists.
But
because
also
of
has a conditional use
landfill.
permit.
Yeah, well, I guess what I'm saying is that I totally understand what you're saying, location, except for that we can't undo the past, and so we kind of have to
I agree.
help to contain the future and try to keep these mixed uses a little bit apart while still understanding that there are other uses that can be compatible within those. You know, if I wanna start a ornamental garden, you know, selling ornamental flowers within a residential use, I probably wouldn't have that much opposition unless somebody's allergic to
This
them
is
or
baby
something.
breath.
Right, yeah, well, anyway, so what I'm saying is that there's so many of these.
There's always the exception.
Yeah, there's always these exceptions, and so what we're trying to do is get to the best point that we possibly can. And by, you know, looking at, okay, what is the maximum size available? I think then you start helping them along, because closer to your, residential epicenters is decreasing anyway. You know, so if you start containing your canopy, and help the problem a little bit. And I don't know. I mean, I'm just trying to respond to some of these, you know, comments and thinking about, yeah, you know, somebody could just take a 1,000-acre parcel and go, okay, I'm gonna have however many tier 3s that I wanna put on it.
I'd say in terms of density, if you will, operation size, I get what the commissioners want to explore. I don't know that I can explain it to you in 50 words or less right now, but I get what you're looking for. Odor, said another way, essentially we're exploring a better definition of what is reasonable impact, or if you will, what becomes an unreasonable impact in terms of duration. I mean, this to a point is related to the density question. You know, how big will it be before it generates an odor that is unreasonably intrusive on the quiet enjoyment of your neighboring parcels? Those will intertwine to some extent, and of course, traffic. We'll have to my knowledge, the ADT manuals don't list pot farms. So we may be looking at some local research to try to get a handle on what the actual level of traffic is versus what is the perceived level of traffic. You know,
I think
so-
as long as it's addressed, that's what I'm really looking
One way or the other.
Fair enough, fair enough.
So let's,
Advisory committee commissioners, do you want them resurrected, or do you want it to go straight to the
I
planning
would
commission?
use them if they are tolerant of this process.
I don't know, with planning, you have a lot,
You know,
you have a lot of planning.
Let's throw this out. Planning commission.
Let them
If they
decide.
feel it's necessary to reconstitute the advisory committee, then they can bring that back.
I agree with that approach.
Okay.
A question, just to where we're at on the interim zoning for marijuana farms. We have,
They have to do, we're not gonna adopt the ordinance today.
Yeah.
We're gonna do the amendment process through amending back to the plan. So we're gonna have to keep the interim controls in place.
so my question would be then is, do you think the interim controls are as they are in place, or that the proposed zoning changes should be used as the interim controls?
That's a good question. What do you think?
Can,
perception of the commissioners, the.
Assuming that that's
the-
better.
The two changes, obviously, the two changes, well, the only two changes, but the most sweeping changes, is in your district use chart. If you, if I generate, if it be the instruction of the commissioners, your current interim controls are in place until repealed. Create an ordinance adopting essentially these proposed amendments as a new batch of interim controls. Repeal your previous ordinance, and then the difference would be is anyone coming in now under interim controls would have to apply for a conditional use permit. If you're gonna cite anywhere in the R1 zone, cite
It'd be that
anywhere.
much more rigorous and
Yeah.
reviewed.
So I think that we have, we're gonna make a motion.
You can make a motion to change what?
So I would move to direct staff to contain all of our thoughts in a memo directed to the planning commission and remand the 178290 back to the planning commission for further deliberation.
I second the motion.
Motion second, discussion.
So beyond that,
Yep,
control is.
that was gonna be a different one now.
Okay. No further discussion from me.
No further discussion, all in favor?
Alright,
Opposed, same sign, motion carried.
so in order to make these our interim controls, we would have to, repeal the current, ordinance.
But we have to refine this before we repeal the current interim.
No, because these are gonna be the interim controls, because they contain conditional use permits.
Oh,
So
okay.
these would
Okay,
replace,
all right.
this set right here would replace our current interim controls.
Say, if that be what the commissioners wish to do, I will prepare an ordinance adopting these amendments, the 178290 and 178220 as interim controls. That ordinance will also repeal the ordinance that adopted the previous batch of interim controls, and that ordinance will set a public hearing to meet the requirements of 3670, 795, moratorium and interim control. We need to have the 60 days.
So I would move to direct staff to create an ordinance making these interim controls, repealing the last set of interim controls, and setting a public hearing for, public testimony on the new interim controls.
Second the motion.
Is that the, I don't know.
Sure, we don't need this, I don't think we need to cite this.
What is it?
It was just. the
We just, it had a number on the.
Oh,
But I don't think we need to cite the ordinance number in the motion. He cited.
Okay, motion second. Discussion.
motion's to staff.
Yes, I oppose if the commissioners are prepared to work with the clerk of the board to actually give me a public hearing date. And I'll just build it in the ordinance, otherwise we can do it when the ordinance is in front of you, however you wish to do it.
Right now. She likes right now.
Okay.
I do.
So, how much time is,
Anywhere within 60 days from date of adoption. And that the public hearing will be to discuss the interim control.
Correct. So if we adopt, if you prepare this, we could adopt this tomorrow,
Good,
and it would be anywhere within 60 days of tomorrow.
correct.
so that would, sometime September or October, before the end of October, rather. But
slot. Of course, we don't have one on Labor Day, so the 3rd's out, the 10th. We have our discussion with U.S. Fish and Wildlife, and some
17th.
other things.
We had a call earlier from Zach Kennedy, who wanted to update the board at 1 that day on the 17th. I have not, it's tentative, still need to talk with the director about it and the board about it and see if that will work and then get back to Zach. But
Maybe we could set it for 2 o'clock on
we
the
can do
17th.
it,
Yeah.
that would be,
Keeping in mind your notice requirements, we'll gin up assuming we get a date set and you adopt tomorrow, that will go in for publishing on the 5th. We traditionally, you make them, we usually allow at least 10 days.
that would be 12.
Yeah, so we can make that.
So, I would move to amend my motion to set the public hearing date for September 17th at 2 o'clock in the afternoon.
Second motion.
Okay, motion, we're gonna go on the amendment, motion second. Discussion. Hearing none, all in favor?
Aye.
Aye. All same sign, motion carried. On the body of the main motion, we already had a motion second. Discussion. Hearing none, all in favor?
Aye.
All same sign. And I guess we are done with our public hearing. We don't need to, this isn't gonna be a continued public hearing, it's gonna be.
No, you've taken an action.
Exactly.
You've remanded it back to the planning
All right,
commission.
So we'll close the public hearing for today.
Thank you, commissioners.
Sorry, Jeremy, but